Hey, this is Bill Gross, the LA probate expert. And today's question is you discover that you're an heir on a property, somebody passed and left the property with a reverse mortgage on it. What do you do? So there's a couple things. I'm going to give you a few points to go through. Number one, I would say that if the property is held in the name of the individual person and there's no other spouse, then if that person's passed, the probate's probably going to be required. Now, I'm not an attorney, and I can't give you legal advice, but I can give you procedural advice and information. So if you're not sure how the property was titled, you can reach out to me and I could pull up the public record information and see how the property was held the last time it was held. It's the first step that any attorney would need as well. So you can reach out. But the number one question is, did they have a trust set up, which is the smart thing to do? And if they didn't, we need to check the title. And if they did not, and send their name individually, then a probate's probably going to be required to exchange the title of the property. Second is normally when somebody passes, you have about 60 days after the death to send a written request, usually by fax, for an extension of time because technically the loan's due upon the death of the borrower. And so you can ask for time, and usually they'll give you time. They're going to find out. They'll send a letter. And in general, my experience is they'll give you about 6 months before really putting the pressure on. Now, if they don't get a response and they turn it over to a company they assign it to, those companies just want to foreclose. So really you want to reach out to the initial lender as quick as you can and let them know that you don't have authority yet, but that you're working on it, and there's a name and a phone number they can call to verify. You get their contact information and get started. Oftentimes with estates, I'll represent them. I'll sign a listing agreement that's not binding, but at least it gives the relationship between me and the potential heirs. And I'll contact the lender for them to get that process started. But you want to contact the lender right away. Now, the third thing you want to do is you want to follow up and see if they're going to give you time or not. And oftentimes they'll ask me for a listing agreement. They'll ask me if the property is listed in the multiple listing service. And then they'll look and expect it to get into escrow within the 30-day period in today's market. You can't really do all that without the full authority, the authority granted by the court. So that's what we're trying to get to. And so you want to get the property listed when you can and show the lender that you're working on it. Now, what you want to do then is, as quick as possible, file for petition for probate, if that's what's required. I can help you with that. I work with some attorneys. We also work with an attorney service that can save you money. In many cases, I can get a service whose cost is under $1,000. If it's a simple probate, if you're the only heir, if there's no objectors, there's nobody fighting over the property, if it's a simple process. And that can move very quickly. But it's important to get the petition filed. You also want to get your bond pre-approved, because what happens is if you are given authority to sell the property with full authority, normally the court's going to want a bond to ensure, in case there's creditors or taxes due, that those get paid as well. And too often, borrowers will wait until they get the approval, then apply for the bond, and then find that takes another couple of days, or there's paperwork, takes another week or two. If you're pre-approved for the bond, then you can submit that with your order for the judge to sign right away, and you can get your full authority and the signed order within days, not within weeks. Now, if the property's in foreclosure, and I get these phone calls all the time, that they waited 3 months, 6 months, didn't know what was going on, tried to live there for free, didn't see any mortgage payments, ignored the letters that came. If it gets to foreclosure, there's different levels of foreclosure, you have to move quickly. Most commonly, you'll get a notice of default, and that gives you about 90 days, and then they'll follow a notice of trustee sale after that. So if you've only have a notice of default, you have some time, but you don't want to play around with it. If there's equity involved, you want to move quickly. So one of the options is you can have an attorney file special letters of administration, which basically says to the court, we don't have the letters yet, but we want special letters, we want special approval to move the house right away. And there are cases where, and particularly if there's objectors and fighting and they can't get the approval to be the administrator executor, they at least can get the special letters approved. There's two different heirs. They may have to agree on who that person is. I've had parties where there's two siblings fighting, but the attorneys agreed to bring in an experienced agent like me to represent the state and at least get the house in the market and sold, and then the money out, and they're fighting over the money instead of fighting over property, risking it being foreclosed. So you might want to consider getting the special letters. Now, you really want to almost always get full authority. That means that you can sell a property, and the only thing you have to do is, even though the law doesn't require it, title companies require a notice to be filed of proposed action. And basically that puts any creditors and any other heirs on notice that you're planning to sell the property and how much for. If everybody's on board, there's no reason not to do that. If there's an heir that's arguing about the price or the terms, that's when they can raise their hand and be an objector. But if you have full authority, then the court will allow you to sell the property. You do not need to go back for court approval. Court approval requires you to sell the property, get it into escrow, then file with the court and go there for a hearing. And oftentimes the paperwork is very particular. It can get delayed a month or two. And again, with a reverse mortgage, you're losing equity every day and your risk of foreclosure if you wait too long. So again, you want to request full authority if you can and streamline the process and have your bond approved. Last is you want to have the house listed as soon as possible. So what I typically do with clients is we walk the property, we shoot pictures, we get a marketing plan together. We're literally ready to issue the multiple listing service once the seller assigns the documents. We have the documents already done. So the second we get the approval, we e-sign the documents, and then we can issue the multiple listing service. And that saves my clients days, if not weeks of time. Because what happens so often, I find, is they're waiting around. And again, the equity is just being eaten away. No seller I've ever talked to in a probate had excess money they didn't care about. Many sellers I've talked to have watched equity deteriorate over months. It could be $3,000, $4,000 a month or more of that equity being eaten up by delays that are needless and administrative. So the key to all this is plan ahead. If you have questions, I know I talked quickly. We covered a lot of material. Call me, text me, email me. Let's get together and see how we can protect your interest in the property. I'm Bill Gross, the LAProbateExpert.com. I'm here to help you any way I can. If you're an attorney, I'm here to work with your clients. So as always, make today